to 1900. 1900 to 1920, extremist period. Lal Pal Bal, Lala Lajpat Rai, Bal Gangadhar Tilak, Bipin Chandra Bose. So, extremist period. When Gandhi came from South Africa, so from 1920 onwards until the independence and until his assassination. So the period was known as Gandhian period. So here non-cooperation movement, non-violence, civil disobedience movement. We know the different stages of Indian national movement. So we have by 1946, 1942, Quit India movement is a famous incident in the Indian national movement. Then by 1946, Britishers allowed to give the freedom. Then they, of course, they implemented their divisive policies, which were, the seats were sown under 1909 Government of India Act on the basis of Minto-Morley reforms. Separate electorate was introduced. There the partition seats were sown. So 1919, we know Montague-Chelmsford reforms. So their Simon Commission and all these are there. By 1946, they allowed Quit India movement resulted into the acceptance of the Britishers to give the freedom. So Britishers put a challenge. First you prepare your constitution, then we can consider your freedom. So Constituent Assembly was formed in 1946. So by 1947, August 15th, we had the partition plan. Pakistan was divided, and there the members elected from Pakistan side left the Constituent Assembly. Dr. B.R. Ambedkar was elected from Punjab with the help of Muslim League. So his membership was lost. Then Nehru and others considered Ivor Jennings to request him to prepare the constitution for Indians. It is Mahatma Gandhi who suggested that Ambedkar should be invited to the Constituent Assembly. The Congress member from Bombay resigned to facilitate Ambedkar to be elected to the Constituent Assembly in by-election. Like that, he entered into the Constituent Assembly. He was made as chairman drafting committee, and Sir B.N. Rao, who is the architect of Government of India Act 1935, was made as constitutional advisor. Several members were there in the drafting committee, but unfortunately for different reasons, they could not participate in the drafting process of model constitution because somebody left to India, left to foreign country, somebody because of his ailment he couldn't attend, some died, like that. So the entire constitutional making process was shouldered by Dr. B.R. Ambedkar. In Constituent Assembly also, Sir Alladi Krishnaswamy Iyer recognized the contribution of Dr. B.R. Ambedkar. So B.R. Ambedkar also acknowledged the contribution of Sir B.N. Rao, Benagala Narasimha Rao. So he is the constitutional advisor, an ICS survey. So he visited several countries on behalf of Constituent Assembly to get the opinion of expert opinions. In the process, he visited England, Japan, and USA also. So he took several advices from them, particularly in making of Article 19. Justice Frankfurter advised him. In American Constitution, we had no restrictions on it. So you please include the restrictions. So 19 clause 1 had originally 7 freedoms. Now after deleting this right to property, now 6 freedoms are there. So from 19 clause 2 to 6, various restrictions were inserted in the constitution because of the advice given by Justice Frankfurter to Serbia. In Article 21, which plays a major role in Indian citizens' life, because no person's life or personal liberty shall be deprived except the procedure established by law. There also, under American Constitution, we have due process. No person's life, liberty, and property be deprived except due process. Then, American justice advised be and law. If there is due process, judiciary will create some problems. That's why you take procedure established by law in the place of due process. All these are there, but in the process of making of this Indian Constitution, and it survived. The success of Indian democracy now today, after 75 years, is the success of Indian Constitution. Because after having taken note of different experiences of different constitutions, from American Constitution we took Bill of Rights. From Britain Constitution we took rule of law and parliamentary democracy. From Irish Constitution we had directive principles of state policy. From socialist constitution like USSR, we took fundamental duties. From Australian Constitution, from Canadian Constitution, we took federal provisions, federal system. So from Japanese Constitution, this procedure established by law was taken in the place of due process. That's why whatever good for the country were taken while making the Constitution by the drafting committee, which is adopted by the Constituent Assembly on the day 26th November 1949. That is what is Constitution Day or Law Day. As our Vice Chancellor mentioned previously, it was confined to Supreme Court. On Law Day, Supreme Court conducted one function and 4 or 5 professors, famous advocates and retired judges were selected and honor on that particular day. And legal institutions, law colleges, recently law universities, the functions were confined to that. But because of the importance of the Constitution, because of the importance of the law, now everybody should know the attempts to make the Constitution of India, which is imbibed various values, constitutional values and morality. And particularly, the reason after the 75 years is not an ordinary thing. The success of, we had the experience of USSR. We had the experiences of West problem. So the Afghanistan problem, Pakistan, where the same nations were formed on the same date. But the success of democracy owed to Indian Constitution. That is the strength of Indian Constitution. So who made this Constitution more strong? Particularly, Constitution is not an ordinary legal document. Constitution of any country, it is the Renna, it is the fundamental law of the land. Whatever law you have, whatever the legislations you have, ultimately all are to be tested with the touchstone of the Constitution of India. Because it is the fundamental law of the land. So it is not a mere legal document, it is a meta-legal document. It is a political document, economic document, and social document. It reflects the people's political, social, economic aspirations. So that's why, right from 1950, 26th January, the Enforcement Day, which is being celebrated as Republic Day. So the Adoption Day, November 26th. The Enforcement Day, 26th January. From there, From that day, India became republic. So we the people of India, having solemnly resolved to constitute ourselves into a sovereign democratic republic originally, in 1976, 3 words were inserted: socialist and secular, along with integrated. Recently, 3 days back, Supreme Court of India delivered the judgment. So when these two were to be removed, when a petition was challenged, when a petition was filed to remove these 2 words from preamble, but Indian Supreme Court did not accept. So the reason is to fortify the spirit of preamble declaration, you can add socialism now is not a real sense of socialism, or Fabian socialism, or Nehruian socialism, or real socialism in the sense of Russian model or China model. So socialism now, as understood by the judiciary 3 days back, removal of inequality. So providing equity and justice to the people is socialism. Secularism, it is not a Western concept of secularism where state has no religion. Here secularism in Indian context is samadharma samabhava, equality of religions. So that's why we have this sovereign, socialist, secular, democratic republic assuring the equality of justice, political, social and economic, and equality of status and equal opportunities, liberty of thought, expression, faith, worship, and to promote among them all fraternity, assuring the dignity of the individual. So the date which was adopted, that is what is 26th November 1949. So to the preambular values are reflected throughout the Constitution, throughout the text of the Constitution of India. There is these constitutional philosophy is reflected in preamble, that is brooding omnipresent in the Constitution. You refer any article of the Indian Constitution without violating these constitutional fundamentals, the understanding of that article is not possible. So if any interpretation is to be done, if two options are there in the interpretation, so the interpretation which is furthering fortifying the spirit of constitutional philosophy, which is declared in preamble, is to be accepted. That aspect is there. Then actually, when we had this law day, why we are remembering these constitutional makers and the constitutional assembly's contribution? The first provisional president is Sachidananda Sen. So in the first the Constitutional Assembly president is Dr. Babu Rajendra Prasad and various other members. So their contribution on the fundamental right chapter, on the directive principles of the chapter, various discussions were there. So viably they were taken. That's why when Ambedkar was asked, what is the important article in your view in the entire Constitution? Then Ambedkar said, Article 32, which confers the duty on the Apex Court, Supreme Court of India, to protect and enforce the fundamental rights of the people. Fundamental rights are given to the people. The corresponding duty, responsibility is imposed on the Supreme Court. Coming to the Supreme Court with the contention of violation of fundamental right itself is a fundamental right. That's why without Article 32, Constitution has no meaning, according to Ambedkar, which is true. So that's why we have to know the constitutional making process and the values which are cherished through the constitution process. And at the same time, of course it was brought in 1950. In order to make constitution viable, flexible, so the amendment process was provided. So any constitution is not a dead tree, it is a living tree. So constitution should be made dynamic. It should not be static. Constitution can be amended according to the needs and expectations and aspirations of the modern society. So that's why, particularly, John Rawls referred a theory in such a way, the original contractarians. Of course, for India, even we forgot about the history and others. By making the constitution, Indians formed the Indian nation. So the original contractarians in the formation of the state through Constitution of India were in 1950. But the new social contractarians for every year, for every 5 years, for every 10 years, their aspirations were changed. The new social contractarians' expectations have to be incorporated into the Constitution. Otherwise, there is no meaning of constitutional functioning. So that's why Constitution provides constitutional morality, constitutional philosophy, constitutional legitimacy. So when there is legitimacy and legality, generally the judge has to take in favor of legitimate expectations. We have a lot of expectations, but all our expectations cannot be protected by the political state or the organs of the political state, whether it is legislature or executive or judiciary. So the legitimate expectations of the people can only be addressed. So the legitimacy, the various 395 articles, originally different parts are there. But if one article has conflict with another article, so the legitimacy promoted article should be promoted, should be allowed valid. When there is a difference between legality and legitimacy, legitimacy should be accepted, and the people expected the legitimacy of the constitutional philosophy. That's why when there were some attempts to make the constitution unfunctional, particularly various constitutional amendments were brought. First Amendment, Second Amendment, now 110 or above amendments are there. Particularly until 1963, the Indian Judiciary accepted the amendments, whatever brought by the Parliament, under the influence that all those were constitutional makers and freedom fighters, and they fought for the nation. So they should think about the welfare of the nation. So whatever amendment they brought, say for example, Jamindari abolition through first constitutional amendment, various constitutional reforms, those were accepted. But by 1968-9, at the time of Golakanath, the politics were changed. There were some attempts to subvert the constitution. So then, first time, the Supreme Court imposed the limitation through Kokasubbar. You can amend any provision of the constitution, except fundamental rights. And Kokasubbar understood that preamble was not part of the constitution. The parliament which has the power to amend the constitution has no power to amend the preamble. In such way they restricted. But when the various several amendments were brought, all those were challenged in Keshavananda Bharati. Keshavananda Bharati allowed that preamble is also part of the constitution, but there are some basic features. Basic structure of the constitution should not be disturbed, should not be amended. Subject to the basic structure, Parliament can amend the constitution. So in the process, particularly they understood various things. Of course, it is 7-6 judgment. Out of 13, 7 judges created this basic structure, 6 opposed it. But later, in Indira Nehru Gandhi versus Rajanaran elections case, Minerva Mills, slowly the Indian Supreme Court accepted basic structure as one of the important protection for continuing the constitution. Because of basic structure, Indian constitution still survives. So some attempts were there, particularly during emergency, what happened? during national emergency, fundamental rights can be suspended under Article 352. The 352 national emergency can be imposed. 358 is immediate suspension of 19. 359 other fundamental rights. All those were experienced in 1976 when national emergency was imposed. But only one minority judge, H.R. Khanna, 4 majority judges allowed the amendment, allowed the suspension of fundamental rights, including Article 32. Then H.R. Khanna gave the minority judgment. It is immaterial when a human being is born. He acquires inalienable sacrosanct values, non-transferable sacrosanct values like life, equality, liberty, which cannot be negotiated by the state. So fundamental rights, human rights, are non-negotiable. That minority judgment became the majority judgment in Maneka Gandhi versus State of Union of India. So that's why Supreme Court liberalized its policies to promote the constitutional philosophy. So that's why we have to remember the contributions of the great leaders, luminaries in the constitution making process. That's why Ambedkar cautioned, however good a constitution it may be, it may turn out to be bad if the people who are called to work upon it are bad enough. However bad a constitution it may be, it may turn out to be good if the people who are called to work upon it are good enough. So it is not the constitution, the people who are called to work upon it, maybe a legislator, maybe a judge, maybe an executive. That's why Palkiwala warned at the time of Keshavananda Bharati case. He developed the particular limitations on the amendment power of the parliament. So if executive ridden parliament, now almost legislatures became executive ridden legislatures. So a top leader will be the chief minister or prime minister, whoever it may be. So he becomes more powerful. So executive ridden legislature. If executive ridden legislature, if Indira ridden parliament was allowed to amend the constitution at its will, there was a danger in the process of amendment. Indira can mend and end the constitution. So that warning was still continuing. So in a democratic country, what is the price of liberty? Eternal vigilance is the price of liberty, unless the people are awakened, unless the people are known about what is going on. So that's why for every 5 years we had the elections. That's why Abraham Lincoln's famous quotation. So the ultimate sovereign power is with the people. People temporarily confer their sovereign power on the elected representatives. So the elected representative who tries to dilute the constitutional spirit, he will be repeated, he will be replaced. So the constitution should not be replaced. Constitution violators should be replaced. That is the concept. Then actually the contribution of legislature in strengthening the Constitution of India, if you take various other things, of course, whenever a legislation was challenged and it was interpreted and treated valid or invalid, then only we have that particular legislation. But in day-to-day business, various legislations are being made through legislative process of the parliament and various state assemblies. So the contribution of parliament, the contribution of legislature to strengthen the constitution is immense. We should not forget about it. So say for example, when parliament brought this National Judicial Commission appointment, Supreme Court struck it down as violative of basic structure. You are interfering in the independence of judiciary. So collegium system already was there. In order to replace the collegium system, you brought the legislation. So which affects the independence of judiciary. So it should not be valid. So that type of legislations we know. But in day-to-day process, GST bill, who challenged it? So many important legislations are there. That's why the contribution of Parliament, the contribution of various state legislatures should not be forgotten in the strengthening of the Constitution as stand it is today. So it was further strengthened. So when we come to the contribution of executive, of course, as long as executive is accountable to the Parliament, the policies taken by the executive which are to be taken into consideration. And we have independent election commission process. So because of Indian election commission is independent one, and it is the only body which exercises all the three powers. Election commission exercises legislative powers, exercises judicial powers, exercises executive powers. So once elections are started, it is the the complete independent body which conducts the elections in a just, free and fair manner. So that is to be understood. Then the judiciary, when you come to the role of the judiciary, initially for the first 10 years, the judiciary was criticized. When government and executive wanted to bring socio-economic reforms, judiciary was obstructing in the name of the protection of fundamental rights. So that was understood as, the first phase was understood as Oxbridge culture trained judges. Oxbridge culture trained politicians, trained legislators. So they were educated either in Oxford or in Cambridge. So which gave more importance to the property. So that's why Indian judiciary showed much interest to protect the property as a sacrosanct value. Without they thought in the initial stage was, without property, human being cannot enjoy his other fundamental rights. So property protection, right to property was fulcrum of the fundamental rights. That was the first stage. So in order to dilute it, several legislations were brought by the Parliament and various state legislatures. So ultimately, the stage came, right to property was removed from the fundamental right chapter through 44th constitutional amendment. Of course, unfortunately, recently, the former Chief Justice, recent Chief Justice, Chancellor made a comment of Justice Krishnai's comment regarding the judgment where the compensation need not, when the government, when the state took the property from you, a work property of 10 crores, you need not expect the equivalent market value. So the compensation paid is to be looked into the in the light of whether that amount is sufficient to have a peaceful, reasonable life. Now, because of the market economy, we have, that's why there is a criticism regarding this. Who is a rich man? Crorepati, what we say, earning lakhs and others. Poor and rich diversion was there. But from 1990 onwards, islands were created. Apart from rich and poor dichotomy. Who is a rich, who is a poor? Poor may be below poverty line, rich may be reasonable, middle class. But apart from this, islands were created. An island of business tycoon with 1 lakh crores rupees or 10 lakh crores rupees. Adani, Ambani, politicians, islands were created. So that's why that problem is also to be addressed. That's why the problem is we have equality, dynamics of equality, which promotes distributional equality. The wealth should not be concentrated in the few hands. Prevention of the concentration of economic power and material resources of redistribution are the directive principles under 39 B and C. So which are real articles for the implementation to achieve any social justice in the country. The challenges before the country, the challenges before the Constitution of India are how quickly we can move from this conservatism, this orthodox feelings, to a modern, vibrant, dynamic human life. So that is what is to be expected. So that's why the contribution of legislature, the contribution of judiciary, the contribution of so judiciary, what happened? Even 1971 right to property was protected, RC Cooper. But the emergency experience, after having the experience of emergency, the post-emergency era, judiciary coming from ivory tower started understanding the problems of the people. So for which judiciary developed various doctrines, public interest litigation, awarding compensation for the gross violation of fundamental rights, and judicial activism, and even the appointment of judges. All these were possible under the Constitution of India. Now judiciary come forward to protect the fundamental rights and all the rights of the people. So that's why the separation of powers is there. Of course, maintaining this, they are trying to protect the constitutional spirit. That's why the success of Indian Constitution is the success of Indian democracy with constitutional values like accountability, transparency, good governance. So at the time of the framing of the Constitution, we had justice, equality, liberty, and fraternity. So in order to achieve justice, equality, liberty, various mechanisms are provided. Various legislations were provided, various executive actions. Now, the leitmotif of the constitutional spirit in the initial stage were three: justice, equality, liberty. Now, the modern India today should run with leitmotif of fraternity, solidarity, and diversity. So then only the security, fraternity should be there among the people. We have to meet India. At one stage we had Quit India movement. Now the present generation should have Meet India movement. So congregation, consolidation, solidarity among the different people as a nation. We as a nation should have a common cause. That is what is the purpose of organizing Constitution Day celebrations as our Vice Chancellor told. So it is not the celebration should not be confined only to these type of primary institutions like law colleges and courts and others. So everybody should know. In America, when I visited 2 times or 3 times, so in elementary school education, they were supplied with constitutional text. Their constitution is very simple. So excursions were conducted to visit Parliament, their Parliament and Lincoln Memorial, Washington Memorial. The reason is in order to generate the spirit of nation's solidarity, nation's security is very, very important. So that's why the conducting of these type of programs is to express our solidarity to the constitutional philosophy. As long as Constitution of India is there, nowadays some intellectuals expressing their thoughts without without adhering to constitutional principles and norms, some people at the helm of affairs try to subvert the constitutional philosophy. As long as the Constitution of India is there, there is the protection for Indians. That's why basic structure theory was not lighted by Madam Gandhi. So in her initial period, Madam Gandhi government had a direct confrontation with the judiciary. So wherever judicial decision came, amendment was brought. Again amendment was challenged. So after basic structure was created, Sikri retired. The Chief Justice of India at the time retired after giving the judgment. Immediately Madam Gandhi appointed Justice A.N. Ray, who was the fourth senior one who did not support basic structure, who supported the unlimited power of amendment of Parliament. So the first three judges, Justice Shalab, Justice Segde, Justice Flower. Justice Segde, K. Segde, later on in Janata Party government became Speaker after seniority became president. So these three judges in protest resigned. Within 2 or 3 months, the majority judges who gave the basic structure theory, out of 7, 4 left the court. New judges were appointed, Krishna Iyer, Bhagavati and all these people. But by the time of Indira Nehru Gandhi case, the judges understood the importance of basic structure. Without basic structure, constitution cannot be survived. Some dangers may be there in the name of parliamentary amendment process or whatever it may be. So, in Indira Nehru Gandhi, they first time recognized, even only one majority judge was there, H.R. Khanna. All the other 4 are who gave the minority judgment in Keshwananda Bharati. All 5 gave unanimous judgment in such a way that Madam Gandhi's government brought 39th Constitutional Amendment. Under that, President of India, Vice President of India, Prime Minister of India, Lok Sabha Speakers elections cannot be challenged in any court on any ground. They were given immunity. So even electoral, crimes were committed and they were not answerable. That amendment was struck down by all these 5. And they held just free and fair elections are part of basic structure of the Indian Constitution. And Madam Gandhi did not yield. So she asked, second time she overruled the precedent. So instead of making Justice H.R. Khanna as Chief Justice, because he gave minority judgments and all these things, Justice M.H. Beg was elevated, appointed as Chief Justice, and Justice Beg constituted 15 judges bench to overrule the Keshwananda Bharati. So in the process, Krishna Iyer was invited by Madam Gandhi for breakfast. All these were revealed in one conference when Krishna Iyer was alive in Delhi. So he told us, when Madam Gandhi put a proposal, you should be there in the 15 judges bench. Then Krishna Iyer politely said, today you are here, tomorrow you will not be here. But if basic structure is the safeguard to protect the Constitution of India and the democracy in India, you please drop the idea of overruling the basic structure doctrine which was promulgated in, which was provided in Keshwananda. Then she dropped the idea. If you observe the political life of Madam Gandhi, after became second time as Prime Minister, until her death, she never interfered in the judicial process. Right from her Prime Ministership up to emergency and all these things, she was confronted to approach with the judiciary. So because life will be changed. So that's why your individual interest should be in consonance with the social interest. If your individual interest is conflict with the social interest, you should sacrifice it. You have to promote the social interest, which is beneficial to the society. So thank you very much for giving me this opportunity. Thank you.